they are hearing a flurry of motions from both the defense and the prosecution in Alec Baldwin's involuntary manslaughter trial. The decisions that the judge makes today will really impact the evidence that the jurors hear once they are seated, and we think that that could happen tomorrow. It's possible that jury selection goes on into Wednesday. We're not 100% clear on that, but it's anticipated it could just take one day. Some of the more recent rulings that Judge Mary Marlowe Summer has made included barring a state request to bar the testimony of a Rust producer and also a Santa Fe County Sheriff's Department sergeant. That sergeant, Christopher Zook, actually found a gun loaded with the incorrect, improper ammo on the set of Rust. And so the prosecutors were seeking to exclude those witnesses. The producer on the set of the film, Ryan Winterstein, he was the one they wanted to exclude as well. They said, we didn't get to interview these witnesses pre-trial, but the judge said, I don't think you're really prejudiced by that, so I'm not going to bar those two men from testifying. So that was a win for Alec Baldwin's defense team. Then later on, there was another ruling regarding an expert in safety guidelines and whether or not he should be allowed to testify regarding what a producer's duties and roles are on a film set. And the judge said that the prosecution could present him to discuss as an expert safety guidelines on the movie set, but he could not testify about the role of a producer because he had never worked as one. So those are just two of the big rulings that have come down today in this case, and many more are expected to come as the hours roll on this afternoon. Terry.
Angenette, one of the things I was wondering, you're in that courtroom. How do you think the arguments are going in terms of who's doing a better job? It looks like Alec Baldwin has an excellent defense team.
Yeah, I think Alec Baldwin does have an excellent defense team. Luke Nikas is a really good lawyer, as is Alex Spiro. Luke Nikas is handling the lion's share of the motions today. He really is the lead on this case. They're very experienced, so they're coming in here and arguing their case, and I think they're doing a good job. The prosecution has lost some of their arguments, but this is a different kind of case, Terry. You know, this is not a whodunit per se. We know what happened on the set of Rust. Really what the jury is going to have to determine is whether or not Alec Baldwin is criminally liable. So it's a kind of a different kind of case from what we're used to seeing here on Law and Crime.
Right, and we know that Alec Baldwin is in that courtroom. We weren't exactly expecting him to come in, but he did come in. What's he doing right now? What's his demeanor like?
Yeah. Well, I think he's very engaged. You see him taking notes. He's paying attention to all of the rulings from the judge. And Terry, you know, I actually thought he might show up today. I saw him here last night in Santa Fe. So I kind of thought to myself, he's here. Why wouldn't he show up and be engaged in what's going on? Because these motions that are being decided today really are going to be pivotal in his case. And so he hasn't shown up. He's waived his appearance to all of the other pretrial hearings, but I kind of had this hunch and this feeling maybe he will show up today because this is the last day before jury selection begins, and he was here.
Exactly. Last question, Angenette. What do you expect going forward? Do you think Alec Baldwin will be there for the jury selection, actually?
I think so. I mean, I think it's important for him to be here. He's the defendant in this case, and I think that he has to be present for jury selection. I guess he could try to waive that, but really he's waived his appearance for pretrial appearances. The trial really starts with jury selection. So I think he probably has to be here and should be here.
Excellent. Angenette, thank you so much for coming on, and we'll check back in with you soon. We just got a lot of great insight from you, and what we're going to do now is go back into that courtroom for our viewers. So let's see what's going on with that motion hearing and how things are exactly panning out.
On a movie set. As Vargas put it, it has to be only within the common experience and knowledge of a lay person. Now, how do we know that that testimony is not within the common experience and knowledge of a layperson? Because the state says so in its other motions. And I brought my notes up here so I can get the language exactly right. In one of its in limine motions, with respect to the cumulative expert testimony, that's motion in limine number 8, here's what the state says. Many people, like many jurors, are not at all familiar with safety protocols on movie sets. And many of the state's experts are being called to educate the jury with regard to safe practices in movie sets. On the Jorgensen motion that we just went over, Your Honor, let me read from that one too. Safety bulletins and protocols on the use and handling of firearms on a movie set, as well as movie production requirements to ensure a safe working environment, are not within the average layperson's knowledge. They try to admit Mr. Carpenter's testimony on that too. They say this is specialized knowledge, expert testimony. They try to get experts in on it, but then they try to say it's just lay opinion testimony that the medic can offer, the camera grip can offer. They cannot have it both ways, Your Honor. And in fact, Vargas reversed a conviction when the court allowed that evidence. That was a police detective who was allowed to testify about his experience with a stun gun, how it was used, how it was made, etc. And the court allowed that at the trial level. The defendant said that's lay opinion testimony. That doesn't satisfy that third prong. It has to be tested under Rule 702. The appellate court said, you're right, reverse conviction. That was an expert testifying because the average and common experience is not that of a detective. And so it had to go through the gateway of 702. The state has not offered, has not disclosed Ms. Schaefer, Mr. Looper, or any of the other witnesses on this set as expert witnesses. They never made that expert disclosure. And to the extent they did, we would have obviously filed an eliminate motion to exclude them as experts. They weren't offered as one, so we filed it this way, as experts, because the medic doesn't have the expertise to testify about armor standards, or the camera grip doesn't have the expertise to testify about movie production requirements. We just went through that with Jorgensen. And so this is lay opinion testimony that violates Rule 701, that has not been offered under 702 or met the guidelines of 702, and therefore any witness that they want to testify about any issue outside of what they observed on Rust, what they saw in other movie sets, what armorers do on other movie sets, what actors do on other movie sets, is improper opinion testimony that should be excluded when it's offered by these lay witnesses. Thank you, Your Honor.
If I were the defense, I'd want this testimony excluded also. And let me tell you why it's relevant. Mr. Baldwin, part of his defense, and he's made these statements repeatedly, is I had no reason to think that Hannah Gutierrez wasn't a good armorer. I had no reason to think there was a problem here. This is what he says. He called Jason Bowles' office himself and said, I never had a problem with your client. I never had a reason to think that she wasn't a stellar professional. Well, Judge, you're actually in a unique position because you sat through the Gutierrez trial and you saw and heard the other people, the other crew members who worked on that set come in and say, we knew immediately this lady wasn't following the proper safety protocols. How do we know that? Because Ross Audiego has worked on 60 to 100 films and TV shows. Same thing with Lane Looper. Same thing with Sherilyn Schaefer. She's the set medic. She's paying attention to what's going on with regard to safety. These are not people who are being called as experts to come in and talk about set safety. These are people who are going to come in and say, we had safety concerns on this movie set because we knew from our experience, and by the way, this gentleman was the most experienced person on set, Mr. Baldwin. So if these other folks who had slightly less experience than him had concerns about whether or not Ms. Gutierrez was doing her job properly, this is the way that the state gets to combat the defense of there was absolutely nothing wrong with her. She was an amazing, stellar professional. This court knows that is absolutely untrue. So it is perfectly appropriate for lay witnesses to come in and say, I've been working on movie sets for the last 15 years or 20 years, or in Mr. Baldwin's case, 40 years. And I know exactly how these safety protocols work. And here's what makes it a little bit unique on a movie set, is that the safety protocols that take place between the armorer and the actor and the first assistant director is this thing that happens out in the open where the armorer says to all of the crew members, all of these people who are going to come in and testify, hey, does anybody want to see the rounds? Does anybody want to come and see me load the gun? Because you're the people who are standing potentially in the way. So all of these crew members actually get to participate in the safety check, even though he's a dolly grip, as though there's something wrong with being a dolly grip, even though someone is a first assistant cameraman or a boom operator, they actually get to participate in that safety check because it is their lives that are at risk. So each and every one of these people should absolutely be able to come in and say, I noticed that Hannah Gutierrez wasn't doing her job because Mr. Baldwin has told everyone Hannah Gutierrez was a stellar professional. We're not asking them for a bunch of technical knowledge. Absolutely, I will tell the court, I am not asking any of these witnesses to come in and talk about the difference between dummy rounds and blank rounds. Absolutely not. These witnesses are coming in to talk about, in part, their safety concerns as it related to Mr. Baldwin's conduct and the conduct of Hannah Gutierrez, and we can't really separate those two out because Mr. Baldwin's defense is she was really good. I would also point the court to, this is Farner versus, I don't know if I'm going to pronounce this correctly, Pakar. This is a federal case, 562 Fed 2nd 518. The admission of the lay witness's opinion that the Pakar suspension system was improperly designed due to its failure to incorporate the safety chains was affirmed by the Court of Appeals. Much like the federal courts have allowed lay opinion testimony based on the witness's particular knowledge gained from their employment experiences, keeping in mind this is their workplace, so too should this court. There's a case right on point. Thank you.
A few issues, Your Honor. I'll talk about the cases first, and we'll go back to what Ms. Morrissey said she's going to try to use these witnesses for, and that's expert testimony. The Farner case, it's a design defect case. Farner was driving a truck. The truck suspension failed. There's an accident. Someone died. His widow, he did, and the person in the passenger seat. His widow sued the company that built the truck. She got a person who had driven, his name was Curtis, driven the same exact truck before. Not the same one in the accident, but the same exact make, model, etc. And he said, I drove that same truck. And you fix that design defect by wrapping these chains around the suspension. It was a design defect case where the question was, is that design defect fixable? This was an expert testimony. This was fact testimony. The same with the other cases, the Kate cites, the Valencia case, the Munoz case. Those are cases where the people worked at the company that was at issue in the fraud. And they were asked about that very company when you worked there at the company. What'd you experience? What'd you see? That's relevant to the fraud. They didn't come in and say, I worked at some totally different company. And my experience at that different company, I'm going to apply it here. That's not at all what happened in that case. This case is Vargas, based on the experience that these witnesses had in other movies. Ms. Morrissey told you they want to say, I've been involved in 40 movies before, and applying my experience there to this one, these are the safety problems I had. Even though there's A, that's expert testimony, because it falls right under that third prong, and number two, it is testimony that they are not qualified to give. There's nothing wrong with being a camera grip, Your Honor. There's something wrong with being a camera grip and testifying about the safety bulletins for armors. That's exactly what 701 and 702 say, and Vargas says it's reversible to allow it to happen. I have nothing further, Your Honor. Thank you.
All right, the court makes the following ruling. A lay witness can testify if rationally based on perception, helpful to clarifying an understanding of the witness's testimony or determining a fact and issue, and is not based on scientific, technical, or other specialized knowledge. Particularized knowledge is acceptable here, although I don't find it here on what they intend to do. Lay witness testimony of what they observed on set, providing that it's relevant, as compared to what they saw on other sets, makes a fact more probable than it would be without this evidence, and the fact is of consequence in determining the action, that is criminal negligence. It's they are not going to testify about the safety bulletins. They can only testify about what they observed on set, in this set, and what they observed on other sets, provided that they have a sufficient history to do so. However, again, we're going to have to decide relevance. Okay.
All right, you just heard the motion argument and you heard the judge immediately give her decision there, and I think that is really a good thing to just quickly get this case going. Joining me in the studio to break everything down here, I do have defense attorneys Danielle Jackson, Serena Townsend. Serena, this one is for you. One thing we did notice, this judge is making decisions a little bit quicker than she did in the Hannah Gutierrez-Reed trial. Maybe she's just more experienced now and she knows exactly where she wants to go. That decision had to do with witnesses, crew members who are on the set. She said, yes, they can come on to testify if rationally based on perception, helpful to clarifying and understanding the witness's testimony, but they can't testify as experts. Tell me if you think that's the right decision, and if so, why?
Yeah, I thought it was actually a very good decision, a smart decision by the judge. Maybe she's got some muscle memory at this point from the last trial. Essentially, these crew members are really not in a position to be experts, even if they've been on movie crews before. It doesn't necessarily mean that they're in a position to be able to opine on certain things. So again, they're lay witnesses who can testify that, you know, maybe Ms. Gutierrez didn't do the right thing, but didn't ask about certain bullets, or did or did not load the gun in front of them. Certain things that they actually observed with their eyes and ears, they can testify to. But whether it was right or wrong, or was her job or not, they can't go there.
Exactly. I think it was the right ruling, too. All right. Yeah. Looks like we're going to have a very streamlined trial when this comes back. All right. We're going to take a break, but stick around as we bring you more coverage on the Rust movie set shooting trial out of Santa Fe, New Mexico. We'll be right back.